Welcome to the Know. I'm Ashley Jenkins.
I'm a dog handler.
Yes, you are. You're the best. This is why we invite you to do the Know.
Yeah, that's the only reason.
Remember the Xbox 360 launch and how tons of people complained about red rings of death and the Xbox 360 scratching discs if you moved the console at all while they were playing?
Well, 10 years later, so does the highest court in the United States.
Oh.
Yeah, because the Supreme Court is now debating a lawsuit about the disc scratching design defect that plagued the Xbox 360. And this one's actually a bit of a head scratcher.
All right, so it's not exactly about the Xbox 360 scratching your copy of Cameo, which, for the record, I still enjoyed, even though I recognize it was not a great game, but more about the way the lawsuit was handled. Still, it's got implications for how consumer lawsuits over product defects do get handled, and if you're a 360 owner, Microsoft might end up owing you some money if the Supreme Court rules against them.
It's not bad. In order to understand how this case even got to SCOTUS and what it's all about, we should go back to the beginning.
The lawsuit, known as Microsoft v. Baker, was first filed in 2007 when 9 separate Xbox gamers sued Microsoft over the Xbox 360 scratching their games and attempted to get their case classified as a class action lawsuit.
If you don't know, a class action lawsuit is a lawsuit where the plaintiff represents an entire group of people, in this case, all Xbox 360 owners. There's so much hair flying around.
So much
right now.
dog hair, so much Bella hair.
I have it all over me. Because of that.
That's your life now.
Yeah, well, this is my life all the time. Because of that, class action lawsuits have much larger legal implications and are a lot more expensive for the company involved.
Yeah, in this case, if Microsoft loses, they'd have to offer all Xbox 360 owners in America some kind of refund. Something similar actually happened with Sony last year when they lost a class action suit over the PS3 losing Linux capability. Everyone was then eligible for a whopping $50.
Hey, free money's free money.
Free money.
So yeah, losing that case would be very bad for Microsoft. In terms of the actual facts of Microsoft v. Baker, the plaintiffs allege that Microsoft received 55,000 complaints about the disc scratching by 2008. They also argued that the 360 was defectively designed with even slight adjustments causing components inside the machine to cut deep gouges into a disc.
During the case, one Microsoft manager even gave testimony that Microsoft knew about the defect beforehand. The lawsuit claims that Microsoft considered 3 separate fixes, but ultimately rejected them because it would have cost as much as 50 cents extra to produce each console.
The pain! So Microsoft decided a can of soda was worth more than your shitty King Kong 360 game.
Well, are they wrong?
Maybe not. Maybe that's not the best example. For Microsoft's part, they claimed only 0.4% actually of 360 owners had any problems. And what's more, it wasn't because of a defect, it was because of consumer misuse.
Yeah, according to Microsoft, you were warned in the instruction manual and through a sticker on the console not to move the 360 while games were playing it. Also, don't look it directly in the eye or talk to it. It doesn't like that.
It's very picky. Despite all that testimony and evidence, a federal judge in Seattle denied the class action filing and said each individual person would have to bring their own lawsuit to the court.
Yeah, from there, the plaintiffs filed another lawsuit in 2011 and tried to get the Ninth Circuit Court of Appeals to appeal the certification of their class action lawsuit. The Ninth Circuit, if you're wondering, is a pretty big deal. It's basically one level before you get to the Supreme Court.
It's like the boss you get to before you get to the final boss.
Yeah, mini
it's
boss.
like Ganon before he turns into like the big old pig Ganon. That's a reference that is true. Kdin's not his head, and Brian made a little scoffing sound. And that's where things went really off the rails. There's so much hair still flying around.
There's floaty hair.
And why this ultimately needs to be taken to the Supreme Court, because legally the Ninth Circuit can only rule in a case where the previous ruling was final. The problem is, since they were denied a class action lawsuit, the original individual lawsuit still lived on, meaning the Ninth Circuit Court couldn't actually offer any ruling on them because the cases, they were still open.
Yeah, so then the plaintiffs used what is essentially a legal cheat code, and they found a hole in the system. According to GeekWire, they argued that their cases didn't work at all as individual lawsuits because, come on, by this point the legal fees added up to way more than their scratched copy of Viva Pinata, and really only made sense as a class action.
So, how did they get around the problems of their individual lawsuits? Well, they asked for their lawsuits to be voluntarily dismissed, which made the cases final, and thus under the jurisdiction of the Ninth Circuit, but only on the condition that the lawsuits were then reopened as a class action lawsuit.
So, you're asking for your cases to be thrown away.
Yes.
So that they can be immediately reopened at the level the first judge said you couldn't do.
Perfect.
kind of like going over mom's head and like going straight to dad.
Yeah.
That's the grown-up legal version of doing that.
I did the opposite. Dad would say no, mom would say yes.
Oh, you're like the enforcer, huh?
Oh, I meant like me in my life. When Dad would say no to something, I'd go to mom. Mom was a lot softer on stuff.
I see.
Yeah.
Well, for some reason, the Ninth Circuit was like that. They were like, sure, why not? Once the case reopened as a class action, the Ninth Circuit heard the evidence and cited 3-0 against Microsoft.
For the most part, the question came down to whether or not Microsoft's claims that consumers misused their Xbox 360 negated the question of whether or not the system was sold with a defect. Each of those scenarios violates the 360's warranty from a different perspective, Microsoft's and the consumers.
In the end, the court ruled in favor of gamers. Judge Johnny Rawlinson, who wrote the majority opinion, stated, although individual factors may affect the timing and extent of the disc scratching, they do not affect whether the Xboxes were sold with a defective disc system. Plaintiffs contend that 1. Whether the Xbox is defectively designed, and 2. Whether such design defect breaches an express or implied warranty are both issues capable of common proof.
So, you could say that things went really poorly for Microsoft, at which point they were like, okay, what the fuck? They shouldn't have been allowed to refile at the point for a class action lawsuit because they were already denied at a lower level. And they asked for their case to be thrown away. That's when they asked the Supreme Court to step in.
Which brings us up to now,
Okay.
when the Supreme Court is finally on deck to figure out if that loophole is even legal or not. The arguments were heard by SCOTUS this week, and from the sound of it, the justices actually seem to be on Microsoft's side in this case.
It's such a roller coaster ride. Ronald Mann of SCOTUS blog wrote that things often got pretty heated in the courtroom during the arguments, mostly with the justices pinning down the plaintiff's lawyer about the loophole tactics. Meanwhile, Microsoft's lawyer argued that if you voluntarily dismiss a case, there is no actual final decision to review because you asked the judge to throw your case away.
He sort of got a point. So what happens from here? That's the real question. Are you all going to get a lot of money for your Xbox 360s? The justices have heard the arguments, which now means they get to deliberate and talk about the legal ramifications of it. For this case, it'll be about whether or not a class action suit can be revived by dismissing the case at an appeals level, which will definitely affect the way consumers can get class action suits reviewed and filed in the future.
When this case was first set to hit the Supreme Court, business groups like the Chamber of Commerce lobbied for the Supreme Court to favor Microsoft. According to them, a decision for Xbox 360 players gave too much wiggle room to erroneous class action lawsuits, which are incredibly expensive for business.
Now, following that, the justices will take a vote. One of them will write the court's official opinion, and then the decision will be released.
And after that, who knows? Microsoft might owe you some money for your Xbox 360 and your ruined Perfect Dark Zero.
Yeah.
No.
No one needs money back. Actually, we would all like $60 back.
Yeah,
for
let's
that one.
just do that. Can we just call refunds for that game?
Yeah, so what do you guys think of the saga of the Xbox 360's disc scratching defect heading all the way to the Supreme Court? Let us know in the comments.
Future legal updates about the world of video games. Remember to like this video and subscribe to the know.
And all the reminders of the worst of Xbox 360 launch games.
There's a lot. Hit the Supreme Court. Business groups like the Chamber of Commerce lobbered.
They lobbered it.
I'm just gonna take a moment. When this case was first set to hit the Supreme Court, business groups like the Chamber of Commerce.
The Chamber of Commerce.
Yeah, like the shoes I'm wearing. Shut up, Kdin.